This article is about Supreme Court. The brief history of Supreme Court of India. The promulgation of the Regulating Act of 1773 established the Supreme Court of India. The Indian High Courts Act of 1861 created high courts for various provinces and abolished Supreme Courts at Calcutta, Madras, Bombay, and also the Sadar Adalats in Presidency towns. After India attained independence in 1947, the Constitution of India came into being on 26th of January 1950. The Supreme Court of India also came into existence, and its first sitting was held on 28th January 1950. The law declared by the Supreme Court is binding on all courts within the territory of India. Judicial review. Judicial review का मतलब क्या होता है? To strike down the legislative and executive action contrary to the provisions and the scheme of the Constitution, the distribution of power between Union and states, or inimical to the fundamental rights granted by the Constitution. Next है कि the Constitution declares Delhi as the seat of the Supreme Court. The Constitution also authorizes the Chief Justice of India to appoint other places as seat of the Supreme Court. The Chief Justice of India can take decision in this regard only with the approval of the President. This provision is only optional and not compulsory. Constitutional provisions. The Indian Constitution provides for a provision of the Supreme Court under Part 5, the Union, and Chapter 6, the Union Judiciary. Articles 124 to 147 in Part 5 of the Constitution deal with the organization, independence, jurisdiction, powers, and procedures of the Supreme Court. The Indian Constitution under Article 124 Clause 1 states that there shall be a Supreme Court of India constituting of a Chief Justice of India, and until Parliament by law prescribes a large number of not more than 7 other judges. The jurisdiction of the Supreme Court of India can broadly be categorized into original jurisdiction, appellate jurisdiction, and advisory jurisdiction. Collegium system. The collegium system was born through 3 judges case, and it is in practice since 1998. The collegium system is used for the appointments and transfers of judges in high courts and Supreme Courts. There is no mention of the collegium either in the original Constitution of India or in successive amendments. Controversy over consultation and evolution of the collegium system. The Supreme Court has given different interpretation of the word consultation in the above mentioned provisions. In the first judge's case in 1982, the Supreme Court held that the consultation does not mean concurrence and it only implies exchange of views. ठीक है, तो मतलब कि कंसल्टेशन का मतलब कंकरेंस नहीं है, मतलब कि बाइंडिंग नहीं है, ठीक है, ऑर्डर नहीं है. कंसल्टेशन मतलब कि वैसे ही राय लेना टाइप. In the second judge's case in 1993, the Supreme Court reversed its earlier ruling and changed the meaning of the word consultation to concurrence. ठीक है, मतलब कि बाइंडिंग हो गया. In third judge's case in 1998, the court opined that the consultation process to be adopted by the Chief Justice of India requires consultation of plurality judges. The sole opinion of the Chief Justice of India does not constitute the consultation process. The Chief Justice of India should consult a collegium of 4 senior most judges of the Supreme Court, and even if 2 judges give an adverse opinion, he should not send the recommendation to the government. The court held that the recommendation made by the Chief Justice of India without complying with the norms and requirements of the consultation process are not binding on the government. Through the 99th Constitutional Amendment Act 2014, the National Judicial Commission Act (NJAC) was established to replace the collegium system for the appointment of judges. However, the Supreme Court upheld the collegium system and struck down the NJAC as unconstitutional on the grounds that the implementation of political executive in judicial appointment was against the principle of basic structure, ठीक है, and that is the independence of the judiciary. ठीक है, तो 99th Constitutional Amendment Act 2014 में लाया गया था, जिसे NJAC बोलते हैं, पर सुप्रीम कोर्ट ने उसे खारिज कर दिया, यानी कि कैंसिल कर दिया, और बोला कि अगर अगर इसे NJAC को जो है वो हमारा जो बेसिक स्ट्रक्चर है कॉन्स्टिट्यूशन का, ठीक है, उसको वायलेट करता है। बेसिक स्ट्रक्चर डॉक्ट्राइन जो वो केशवानंद भारती केस 1973 के बाद आई है, ठीक है।